Morning, everybody.
Good morning.
Morning. Hey, good morning. Who's here? I can't see anybody. Who's here?
My video is unable to turn on.
The host has stopped it, it says. Huh. Okay.
Good morning, counselors. You should be able to start your video now. Is anyone still having trouble?
Is able to go on now. Thank you.
You're welcome.
Morning, everybody.
Morning, everyone.
Good morning.
Whew. It's chilly outside.
Just a little bit.
Morning. Good morning, everyone.
Morning.
For some reason my camera isn't working. Can folks see me?
Yeah.
Yep.
Yeah, we can see you.
I cannot see myself. It's an uncomfortable feeling. I'm going to give it one more minute or so just to see if my camera adjusts, but also to get a couple more colleagues on, make sure the co-sponsors and everyone is here, and we'll just get started. All right, I still don't see myself, but we're just going to go ahead and get started. Oh, I do now. Great. This is the Committee on Government Operations, Monday, December 7th at 10 a.m., docket 0684, Ordinance on Surveillance, Oversight, and Information Sharing. Good morning, everyone. I'm City Councilor Lydia Edwards, Chair of the Committee on Government Operations. It is Monday, December 7th. And we're here today for this virtual working session. The ordinance we're discussing is on surveillance and oversight and information sharing. It was sponsored by Michelle Wu, Councilor Michelle Wu, Councilor Ricardo Arroyo, and Councilor Kim Janey. The committee held a hearing on this docket on November 10th, 2020. In accordance with Governor Baker's executive order modifying the open meeting law and relieving public bodies of certain requirements, we're having this working session via Zoom. The public may watch this meeting via live stream at www.boston.gov/city-council-tv. will also be rebroadcasted at a later date on Xfinity 8/RCN82 FiOS 964. Okay. And as a review, the docket 0684 would lay out accountability, transparency, and oversight measures regarding the collection and use of surveillance technology and surveillance data by the City of Boston and information sharing by the Boston Public Schools. The ordinance requires submission for approval by the council of a surveillance use policy for each department that possesses or uses surveillance technology. Submission of the surveillance technology impact report, and if required, a technology-specific surveillance use policy. Prior to acquiring or using any new surveillance technology or surveillance data, and submission of an annual surveillance report for each department for which approval of surveillance technology or surveillance data has been obtained. The ordinance would also create a system limiting information sharing between BPS and BPD, limiting the permitted reasons for creating a student report and the allowable information to be included in the report, requiring reports to be shared with the head of the school and the family of the student named in the report, and requiring, prior to the sharing of the report with an entity outside of BPS, a meeting between BPS and the student with an opportunity for a legal representative to be present, and confirmation that the student report was written pursuant to the criteria outlined by the ordinance, creating a community information sharing oversight board to provide oversight over this section and review monthly reports from the superintendent regarding student reports and requiring training of Boston Student Police and requirements of the ordinance. At the hearing on November 10th, the committee heard from Emiliano Falcon Morano, Policy Counsel for the Technology for Liberty program at the ACLU, Nora Paul Schultz of Unafraid Educators, Valeria Dovalli, lead organizer for Student Immigrant Movement, and Kimani James, member of the Boston Student Advisory Council. Topics discussed included differences between the proposal and the existing BPS information sharing policy, incongruence of incidents that allow for information sharing and sometimes severe consequences, such as addition to the gang database or deportation. The committee discussed the reason for incorporating the information sharing provisions and surveillance oversight in a single ordinance, and the social emotional trauma that surveillance may cause student and adult residents. The committee also heard public testimony. Student, parents, teachers, lawyers, and advocates shared experiences that have impressed on them the need for tighter restrictions on BPS information. I don't believe anyone from the administration attended that hearing. If they did not testify. I will shortly turn it over to the lead sponsors of this matter, but I wanted to just make sure everyone understood the goal of today. It's a working session. I assume everyone has a draft of the document in front of them. The administration, I assume, I will announce shortly who is expected to be here from the administration. I have John Towell from the mayor's office, Sam DePina from BPS, Neva Coakley-Grice from BPS, Mark Racine from BPS, Chris Osgood, Streets, Transportation, and Sanitation, David Elgles from Do It, David Leonard from Boston Public Libraries, Nayeli Rodriguez, or Chris Carter from the mayor's office of New Urban Mechanics. And I assume that we're all here to get to work on this in the language that we think best balances the safety, the transparency, and the accountability that the co-sponsors wanted, and also with the same goals that many of us have as either government workers or those of us who represent the public. This is, again, a working session, so the issue of the yes or no of this ordinance and whether it should or shouldn't happen could have been discussed in the hearing. But if you're not here really to work on the language, then I appreciate that you're here, but we're going to work on this language. In terms of, so again, everyone should have a draft of this in front of them. And I look forward to hearing about any concerns from the administration. And I will turn it over now to the lead sponsors to be followed by the other counselors who have come in. The lead sponsors are, again, Counselor Wu, Counselor Janey, Counselor Arroyo. After those three speak for very brief opening remarks, again, reminding people this is a working session, so we're not introducing this. We're going to go to Counselor Braden, Counselor Savi George, Counselor and Counselor Bach. So of the lead sponsors, Counselor Wu.
Good morning, and thank you so much, everyone. I'm this a long time, many months of work have gone into this from our advocates and our community partners. So really grateful for now really diving into the details and eager to see next steps. So thank you so much to my co-sponsors and everyone in this coalition and the administration for your time.
Thank you. Councilor Arroyo.
Thank you so much, Madam Chair. I just want to thank all of the advocates who have played a role in getting us this far and who will be playing a role in putting together the language here, ACLU Massachusetts, the Student Immigration Movement, the PAIR Project, the BTU Unafraid Educators, and the Greater Boston Legal Services. The purpose of this ordinance is to provide accountability, transparency, and oversight regarding the acquisition and use of surveillance technology and surveillance data by the City of Boston and its agencies and officers, and to protect privacy, civil rights, racial and immigrant justice. And it's also serving a purpose to protect our students in BPS from the immigration deportation pipeline. And so there's a number of different aspects that this ordinance is dealing with, and I think all of us are united in the goals of protecting our residents. And so I look forward to a productive hearing. Thank you, or working session rather.
Thank you. Councilor Janey.
Thank you so much, Madam Chair. I want to certainly thank my colleagues for their partnership and their leadership on this issue. Certainly want to thank the amazing organizations that have put so much time and work into this. Want to give a shout out to the ACLU, Unafraid Educators, and the Student Immigration Movement, and certainly to the administration that is here. I think this is the first time where we're really all together here. So I'm looking forward to for us to kind of dig in and get something that we all like, so that we pass this legislative cycle, which we know ends on a week from this Wednesday. So thank you again, Madam Chair. Looking forward to getting into it.
Thank you. Councilor, now moving on to other councilors. Councilor Braden, followed by Asabi George and Bach.
Thank you, Madam Chair. I just want to echo the thanks and gratitude for all the advocates and the folks who've worked so hard on this ordinance so far. And I won't take any more time. I think we have a lot of work to do this morning. And so thank everyone. And thank you, Madam Chair.
Thank you. Councilor Asabi George.
Thank you, Madam Chair. I'm too grateful for everyone who is here today and looking forward to getting to sort of the work of this working session. Thank you.
Thank you. Councilor Bach.
Thank you, Madam Chair. I just echo my colleagues' thanks to everybody who's been working on this. I think it's really important, and I think we should get to work. So thank you.
That leaves, unless there's any other colleagues that join me since I went through, that leaves me. I'm excited to get to work. So turning over to the administration, and I also, sorry.
Council Flaherty's on, Madam Chair. Council Flaherty's on, but I have no opening comments. I'm tuned in.
I'm sorry, Councilor Flaherty. I didn't see that you came on. I'll just do another call.
I stood in this chair at the last hearing, but I'm here and here to listen to. No worries. No worries. I just want to let you know I'm present and accounted for, Madam Chair. I'm good.
Thank you. I guess another last call out, or not last, but any other city councilors that I missed? I'm checking. I don't see. Okay. All right. So I forgot to announce who is also here from the advocate community, who has done an excellent job in making sure that we were not only held accountable, but had the resources that we need to come into this working session. I want to just pull them up real quick and announce who they are. Councilor Mejia has also joined us. Councilor Mejia, can you hear us? Can you, Councilor Mejia?
For some reason, now I can be seen. And heard. Yeah, I'm here. Don't worry. I don't have anything to say. I'm here to listen and learn and be a part of the conversation. Thank you for hosting.
Thank you. So again, I'm just trying to quickly grab my notes on who's here from. I probably know you all from faces anyway, when I announced you in the. So we have Emiliano Falcon from the ACLU. We have Cade Crockford from the ACLU. We have, I'm doing this by memory, so please. Can't find my notes for some reason. Where am I? I see Valerio Duvali from SIM. I see Elizabeth Badger from PAIR. I see my colleague from Greater Boston Legal Services, Elizabeth McIntyre. Hello. A former colleague, sorry. One day, if you want to join the council, let me know. And I see Nora Paul Schultz, also from Unafraid Educators. Did I get everybody? Sabrina. Oh, how could I forget you, Sabrina? Hi. From SIM? From SIM. I think that's everyone from the advocate community. Okay, and I'm going to give myself a round of applause. That was like on 2 sips of coffee and memory just from faces. So
sorry, Counselor. I think Lena from Unafraid Educators is also with us.
Lena, is your camera on?
Yes, hi.
I'm so sorry, Lena.
No problem at all.
Okay. Ah, Kate, I was so close. So close. That's what you get for bragging. That's what you get for bragging. That's what happens. In any event, I would like to turn it over to the administration. I announced several of the folks who are here joining us today. I don't know if you have a presentation or if you have an order of speaking. John, you're at the top of the list. Were you going to introduce folks, or are you going to do I wasn't sure.
If it's okay, Madam Chair, I was going to just open up a little bit, and then we have a number of people from different departments who are going to talk to the practical implications of the proposal before us, if that's okay.
Okay, thank you.
Thank you, Madam Chair, and all the members of the council, the sponsors, and everyone who's worked on this for hosting the working session and elevating this important issue. As I said, my name is John Toll. I have the honor of serving as a policy advisor to Mayor Walsh. We appreciate and in fact embrace the spirit of the ordinance. Boston has a long-standing and well-earned reputation for innovation and utilizing technology and data to serve the public good. Mayor Walsh wants to remain a national leader in this regard. He also wants Boston to be a leader in ensuring that individual privacy and civil rights are protected and respected. In our view, the ordinance has to be viewed on 3 separate but obviously interrelated levels: the legal, the technological, and finally the operational or the practical. Without question, a meaningful discussion of any of these aspects of the bill could probably occupy a lot more than the limited time we have here today. Regardless, I'm going to try to at least quickly summarize some of the concerns that we have in pretty broad terms. And for the purpose of today's working session, members of the administrations I'll introduce shortly. They'll focus most of their comments on the operational practical implications of the proposal. I'm not an attorney. None of the members of the panel we have today are attorneys, so we can't really speak to the specific legal issues attendant to the ordinance. That said, I believe the administration communicated their concerns to the council that as currently written, it's in violation of the charter and likely conflicts with a number of state laws. I don't believe that opinion has changed. And that's an obstacle that needs to be discussed and worked through. And again, I'm at a bit of a deficit to do that. I'm not an attorney. The next level of concern we have is technological. First, the ordinance is really broadly written. And in our view, it appears that virtually every piece of hardware, software, data set anywhere within city government would appear to fall within the ambit of this ordinance. And this makes compliance with all the subsequent requirements and provisions extraordinarily difficult, if not impossible to implement and execute on. And the cost for doing so in terms of finances, human hours, and the anticipated impact on all manner of services are hard to calculate. In addition, because the process for the continued use of technology, the introduction of new, is fairly long and involved, we're concerned that it might significantly slow down responsiveness. We're also concerned the process might threaten to disincentivize innovation and progress if the path forward is too difficult, time-consuming, costly, or uncertain. These effects aren't localized to any one department or agency, but felt throughout the city government, from public health and safety to education and transportation, climate resiliency, urban planning, equity and housing. There's not an area of city government that isn't utilizing technology and data to deliver services, to constantly improve them, to inform decision-making, and to measure outcomes. The technologies we rely on are often multi-use tools that overlap and share space with one another. These same technologies that are used to improve transportation, education, climate resiliency, measure where our efforts at equity succeed or fall short, protect the public safety, ensure the public health, and so much more, also share space with and give rise to legitimate questions about how we protect people's privacy interests and civil rights. we need to be incredibly careful and thoughtful about how we approach them so that even as we strive to protect privacy rights, that we don't do damage to our ability to deliver high quality and effective services. The consequences of any policy changes that affect the health, the safety, the education, and the myriad of the services on which the public relies, I think need to be really fully understood and communicated before they occur. I'd respectfully suggest this requires more conversation and exploration of each of these levels than has occurred. Our fear is that the costs and the work hours to implement and stay in compliance with the ordinance are, again, incalculably high. I'm not trying to be alarmist, but realistic. So we thought it might be useful to the conversation today if people heard from some of the men and women who do the actual work every day to speak to the practical challenge they anticipate from the proposed ordinance and how they carry out their missions and deliver services to the city. They'll also speak to work already underway to ensure that privacy rights are protected and respected. Again, this is just a small cross-section of the administration. Virtually every department will be impacted, some much more than others. So our concerns are by no means limited to these entities. As I said, technology and data are now foundational to city government, interwoven into every aspect of the things that we do. In order of speaking then, we have Sam DePina, Chief of Operations for the Boston Schools, Chris Osgood, Chief of Streets, Transportation and Sanitation, David Elgis, Chief Technology Officer for the City of Boston, David Leonard, President of the Boston Public Library, and Ailey Rodriguez from the Mayor's Office of New Urban Mechanics. For the purposes of discussion later, we're also joined by Neva Coakley and Mark Racine of the Boston Public Schools, and Chris Carter and Nigel Jacob from Monum, New Urban Mechanics. Again, I want to thank you, Madam Chair, and all the council for what I hope will be a thoughtful conversation. Thank you. Sam?
I'm sorry. I just want to make sure I'm clear on understanding because that was a lot of information. The administration has expressed that they feel that the language, or as it's written, is unconstitutional, violates the charter. Who is that expressed to?
I believe there was a letter sent a couple of weeks back to the council expressing that concern.
So the following people, when the from the administration, they are not going to be addressing any of the language. They'll be discussing the practical impact on their department.
Yes. Again, I think it's still part of a useful conversation, Counselor. You know, there are practical implications to this, and they're far-reaching, and maybe, I think, probably more far-reaching than some people realized, and we thought that would be a useful conversation.
Thank you. We've been joined by Councillor Baker. Before we go into other comments, it's Councillor Baker. I just want to acknowledge you and see if you had any comments.
Thank you. I'm more here to just listen and to see how we move forward with all this discussion. Thank you.
Thank you very much, Councillor Baker. Okay, in terms of the folks who are to testify shortly about the practical implications, I do intend to get to the language of this. So if you can make your comments direct and brief, and if you have any specific language that you are also concerned about, that would be very helpful as well as to why you feel a specific section or specific definition or specific, what, instead of talking about the whole ordinance as a whole concept, if there's this is why this isn't practical because of whatever the section is, that would be extremely helpful. So.
Good morning, Madam Chair. My name is Sam DePina from the Boston Public Schools Chief of Operations. I again want to echo my colleague's sentiment around, you know, our appreciation for the goal of the ordinance and the spirit of this working group. Superintendent Cassellius has been a leader around this initiative and has really pushed the district to a point where we are now. I'm here joined with my other colleague from Boston Public Schools, Neva Coakley-Rice, our Chief of Safety Services, as well as Mark Racine, who's the Director of our OIT department, our technology department. Just to provide some general information, you know, any and all of our cameras in or on our buildings are solely to support the safety of the students and promote the security of our buildings. Recently in September of 2020, after some long conversations with many community members, many stakeholders, we updated and passed a policy regarding preparing and sharing student information reports and other student information with the Boston Police Department. That policy at a high level really gets to the spirit of what we're doing here today. The policy restricts the use of internal safety reports that the safety services officers can produce. They're limited to sick assist, medical emergencies, missing children, or students that do not, or incidents that do not involve student activities such as graffiti on property or vandalism. It restricts the types of student conduct for which safety service employees may prepare and file a BPD 1-1 report. What we're trying to do is make sure that student discipline issues are treated as such and not lead down the path of a criminal record. Incident reports may never contain information about students, including immigration status, citizenship, national origin, ethnicity, native or spoken language, or suspected gang affiliation. So we've set the policy with those information are never ever contained in any reports. The policy eliminates the practice of preparing intelligence reports. Safety services employees are now required to inform school administrators prior to preparing an incident report. School administrators are now required to contact affected students and their families within 24 hours of receiving such notification. And the policy also calls for a monthly meeting with the superintendent to review safety service data. In addition, a school safety working group is required to assist and monitor the oversight of the policy. And the policy calls for annual review by this working group to discuss the policy, discuss the data, and make any further recommended changes. So, again, we're here to advance this work forward, and we're here to support how we can, but we're just unclear as written how the policy will do that. So Mark Racine, like I said, is here to talk about the various technology efforts in Boston Public Schools, and Neva Kostikars is here as well to talk about how the policy is being implemented and with regard to our officers and support as best possible. Thank you.
Thank you. Councillor Campbell has just joined us. Councillor Campbell, if you have any brief opening remarks.
No, thank you, Madam Chair. I'll get back to the conversation. Just have been in support of this issue, this work since years ago when Councillor Wu and Councillor McCarthy and I held the initial conversation on this. So fully supportive, here to listen and hopefully support in any way I can. Thank you to everyone for participating today.
Thank you. Wasn't sure if anyone else from the administration.
Chris Osgood.
Sure, I'm happy to. So Chris Osgood, I have the honor of serving as Mayor Walsh's Chief of Streets. I'm just going to give some very quick sort of contextual comments solely from the public works and transportation perspective, and just reiterating Sam's point that very much aligned with the spirit of this, that we should be only collecting data if it serves a public purpose, that we need to be transparent and accountable for how it's collected and how it's used, and then we need to make sure that we are safeguarding people's privacy in that data. At a high level, the sort of data that is collected within our cabinets falls into 4 categories. The first set of data is data that is really programmatic data, so think 311 or data collected through our bike share program. I believe that this category of data is exempted through 2.1.1 and 2.1.2. The second category of data we collect is enforcement data. This is sort of recognized in this document both through parking enforcement as well as sort of the prospective potential inclusion of photo enforcement. I think this is also exempted in this ordinance in 2.2.2. The third and the fourth categories of data, those two are really about things that would be probably meet that individually identifiable definition. The second 2 categories of data, at least in the first sort of order, don't. One is mobility data. We have a great interest in data about how people in general, not persons specifically, but people in general are flowing through the city, are using our curbs, or interacting in intersections, also that we can refine our streets for the people in the way in which all of us have been talking about. That sort of mobility data, I think we can get to this, but potentially is impacted by this ordinance. And then there's third-party data that is not collected by the city, but collected by private assets in the public right-of-way, which may or may not be included and covered in this ordinance. Just very quickly to touch on some of the high levels of operational things that I just wanted to flag, operational and technical. One is sort of in the definition in 1.3 around individually identifiable. There's the language sort of really focuses on data sets that could potentially reveal individual identities if coupled with other data sets. I think this needs a lot of additional exploration. There's A lot of the data we're collecting about flows of people at large through the city is not data that it would necessarily be individually identifiable. But I think this is an example of where that definition might involve or might include that data if the data sets that we're collecting are then coupled with other information that is brought in for the analysis. The second is around the way in which the exemptions are identified and really thinking about the level of specificity that makes sense for exemptions so that one can sort of future-proof ordinances such as this. This is sort of the entire sort of 2.2 section where the whole world of, in many ways, the way in which people are flowing through cities and the data that's used to support it and the technology that's used to support it is rapidly evolving. And so I think that that whole, that is an area that needs a lot of exploration to make sure that the language is future-proofed in this sort of this period of pretty rapid technological change. And the final one I just wanted to flag was around section 4, which is really around the process of the use of new technology. And it may be my reading of it, but it seems very much like this has real implications for the way in which we partner or the way in which we procure services that will either be in a place where we'll have to get really specific approval about technology before we did something like an RFP and then consequently not benefit from the variety of ideas that may be out there that would be responding to an RFP, or we are seeking approval after going through the RFP process, which probably has its own implications. Anyway, those were just some of the quick ones I wanted to flag from an operational standpoint. We've done and are doing and continue to do sort of a lot of work in this area in large part and with great leadership by the team from the Mayor's Office of Neuromechanics. So look forward to this conversation, look forward to the future conversations on this topic. And I will turn over to John, who's next.
I believe it's Chris Dave Elgis.
Good morning, everybody. Thank you, Madam Chair and members of the City Council for this opportunity to address you today. I will make my comments brief before I go into specifics. As Chris said, we are in alignment with the spirit of this ordinance. It is to our core belief that data should only be collected if it serves a public good and serves a public purpose. And that data that is collected must be stored securely and must be limited to ensure privacy and must comply with all current PII or personally identifiable information security standards in an effort to protect personal identity. DoIT does not currently collect, control, or analyze data for the purpose of individual surveillance. We all take this responsibility very seriously, and it's to that end that we need to continue to be transparent, accountable, and for what data is being collected. In the data privacy usage space, the optimal framework is to recognize the data privacy protections must keep on pace with innovation in Boston and across the US. Where DoIT is specifically focused and where our questions mostly lie is the role of DoIT in supporting all the city departments that are on this call today is really the understanding between the data custodians and the data owners and the providers, and where that responsibility and where that delineation line is set as we support all of our city services with the storage of the data, with connection, with wireless, and really understand where that change is going to come about. We have a variety of different policies in place, from terms of use policies to data protection policies, to be transparent around the data and how it's stored, how it's collected, how it's used. And for us, it's really a better understanding of where that delineation line is so that we can work with our other city partners to understand the implications of this ordinance. And I believe that Chris Osgood mentioned this earlier. Another area that we are also focused on is around technology innovation and future technology as we start to look at bringing on new technologies into the city of Boston, that we understand how these new technologies, whether in the RFP process, seeking approval, or if it's something after that would impact bringing on new technologies in the city. So really to get a clear understanding of that would be very helpful. But that's in terms of Do It and in our role in supporting city services. We act more as the custodians or the provider. So it's really an understanding of the implication across the city in how it will impact everyone from streets to schools to library, et cetera. So that's really the Do It position so for us, it's really around clarification of the language. Because as I read the ordinance as it is written today, it's very broad. And I think John mentioned this at the top of the call, that it could really cast a broad net over all the technologies that we are doing, from hardware to software to services, in everything that we are doing and supporting here in the city of Boston. So clarification on that would be very helpful in really being able to push this ordinance forward.
Good morning, councilors. This is David Leonard, President of the Boston Public Library. I believe I'm next. Good morning to you all. Thank you for the opportunity to offer a statement. As President of the Boston Public Library, it is my job to not only implement policies as set by the administration, but also inform the trustees of the library with regard to any matters pertaining to the care of our collections, our spaces, and in particular, as it relates to today's conversation, patron privacy. In terms of my own experience, my original position at the library was being hired as Chief Technology Officer, having spent 12 years in the private sector working on a variety of IT matters, including data management and enterprise security. So first of all, I just want to remind us that in the case of the library, while also a department of the City of Boston, it is the Boston Public Library trustees who are charged with oversight of collections, operational library policies, and care of buildings. The library has a series of policies, including our appropriate use policy, a draft security policy, and a review of best practices when it comes to escalation of matters relating to difficult patrons, which are clearly being reviewed at the moment and further developed. There are also the matter of patron privacy and access and use of library resources in general, which is in fact governed by state statute, the enabling legislation, and there are specific carve-outs from the public records law for security of those matters. So we believe we may already be in compliance with many of the goals of this ordinance, and we look forward to conversations as they proceed about how best to reconcile the other bodies and regulations that govern operations in conjunction with today's ordinance. As we review the ordinance, as others have stated, there's some concerns with some definitional matters as to the broadest scope of what a definition of surveillance would be, a very broad scope for what is constituted technology that could enable or hold identifying data, and the obligations for reporting seem particularly broad. The exemptions and exceptions, while helpful, we believe need further attention to reconcile with the definitional problems cited above. But we look forward to the conversation and commend the council for a shared interest in oversight of these technologies, greater transparency, and protection of residents' privacy at the highest level. Thank you.
Anyone else?
Hi, yes, my name is Natalie Rodriguez. I'm the technologist for the public realm and I work with the Mayor's Office of New Urban Mechanics. I believe that I'm next, and I'm just going to give a little bit more background on MONUM's perspective. I think we agree with the statement made by Chief Osgood on what we read as the spirit and intent of this ordinance. We definitely want to protect residents from overly broad collections of data, particularly data that could be personally identifiable, either by itself or through a combination with other data sets. And as many of you know, the Mayor's Office of New Urban Mechanics draws on several years of partnering with other city departments, universities, nonprofit organizations, and tech partners to experiment with, co-create, and critique so-called smart city technologies and evaluate their usefulness in fostering a community that is ethical and resilient and open. I think we believe that the trust and engagement of Bostonians is fundamental to any functioning democracy and therefore also to any successful data collection initiative. And to that end, I just want to make you aware of some of the projects that we've been working on that move towards this aligned set of principles on data collection and technology deployment to build and foster trust. In the past year, we've established a set of public data principles to guide the city's data collection and management infrastructure with purpose, security, governance, transparency, and accountability. And this set of principles, which is available on the city's website, is a working document that we're still seeking continual public input on. And that led to our next piece of work, which was a collaboration with the Harvard Law School's Cyber Law Clinic to provide standard language that will begin to enforce these public data principles in RFPs, contracts, statements of work, and data sharing agreements. And we believe that this is improving upon a practice that many departments that we work with have done on a per contact basis. Prior to these efforts, we did some scoping work on technologies deployed in our streets, skies, and sewers to better understand the scale of time and resources that would be needed to collect and centralize an asset database. And for this audit exercise, we worked with a dozen different city departments to understand their use of technology in the public realm. While important, I think that after spending a number of months on it, I realized that that is not a small undertaking by any means and would require budgeted resources to complete. Right now, the scope exceeds one full-time employee working at about 25% time. Two specifically public-facing initiatives are the prototyping of a digital transparency for the public realm signage system as a method for standardizing and communicating the type of technology, the data generated, its owner, and a way to engage with the project manager. And this signage was designed to be deployed alongside data collection devices in the public right-of-way. And we also created a set of preferred practices for the community engagement that's requested of vendors who are deploying new technologies in public space. And this community engagement seeks to make the technology, collected data, the projected use of the data transparent and accessible to everyone. And most importantly, the work seeks to promote more cultural awareness around technology and data and related challenges so that the city's residents can, more knowledgeably and increasingly hold public servants accountable to the use of that data that's collected in the public right-of-way. And so moving on to some of the challenges that we specifically see with this ordinance, while we fundamentally agree on the principles that were stated in the introduction, the challenge that we foresee, I think, are a little bit maybe unintended consequences of some of the wording. And a couple of the examples of that include the use of the terms clear and conspicuous as it relates to the collection of surveillance data. It's not uncommon for third-party data sets to be generated from apps and downloaded onto a phone through software development kits or from vehicle telematic systems that are in a car that a person drives. And even though that individual has, theoretically agreed to terms and conditions to do so, it's likely that it was not clear or conspicuous in opting out of the sharing of that information. And that's addressed in section 2.1.2. One of the language details that would possibly interfere with our ability to open up data sets generated or purchased by the city to the public and research community through the open data portal is section 2.2.7. Perhaps the biggest concern to the work of MONUM, however, is the impact to our collaborations with researchers on grant proposals and other prototype projects with relatively small budgets and really short timelines. So our approach to working with universities and startups has been recognized globally as a leader in the smart city space and keys on the significant strength of Boston as an idea hub, but some of the sections of the ordinance may change that approach. And as Chief Osgood noted before, on the procurement cycle, the same implication occurs for securing grants or even letters of support for things like NSF funding. And that specifically, pertains to section 4.2. For our team, which is focused on prototyping and experimenting with new ways of delivering services and assessing the utility of new approaches to city services and operations, this ordinance creates some significant reductions in the pace with which we would be able to react to the evolving world of technology and inhibit our learning that we will be able to do on experimental technology through small scale deployments. And some other departments who aren't here who would be impacted by this, range from everything from public health, environment and parks, energy, libraries who did speak earlier. So that's just a kind of a broad snapshot of all the different unforeseen challenges I think that we can anticipate with this ordinance right now. And so thanks to Madam Chair and the counselors for having us and including us in the discussion here today. Really appreciate sharing the session. Thanks.
Was that our final speaker?
Yes, it was, Madam Chair. Thank you.
Thank you very much. I'm inclined to maybe turn it over for some quick comments or responses maybe from the advocates. I don't know, to the co-sponsors, if it makes sense to kind of hear their response or concerns or their own suggestions for language, and then open up to all of the counselors to go through a couple rounds. I see Counselor Janey is saying yes. Counselor Arroyo, Mejia. Okay. All right then. So I wanted to go ahead and I know that we had folks testify before. I don't know of the advocates if you had a specific order or if you had some language suggestions. We can start with the team from the ACLU, and then we'll go to GBLS, then we'll go to SIM and Unafraid Educators. And I'm announcing the organizations. I'm not sure which of the what your points would be, but I just let's just go by organization if that's okay.
Great, thanks, Counselor. Good morning, everybody. My name is Cade Crockford. I'm the director of the Technology for Liberty program. I wasn't expecting that this would sound like a hearing this morning. I thought this was a working session, but I've heard some testimony, what sounds like testimony from the administration. So I'll just maybe take a couple minutes to respond to some of those points, and then I'm going to turn it over to Emiliano Falcon Morano from my office, who can talk through some of the actual language. But I was sad that nobody from the administration showed up at the hearing to talk through these points, because I think you all have some legitimate concerns. I don't think that they necessarily outweigh the importance of the ordinance, or that your concerns necessarily mean that the ordinance would impact your work in the way that you think. But they're important. They're obviously important issues to raise. So I just want to go through a couple of them. First off, just as a general matter, we understand on the advocate side that particularly the surveillance oversight section of this ordinance creates new bureaucracy for the administration. Totally get that. That has been the case everywhere these ordinances have passed all over the country, including in Cambridge and Somerville, our neighbors right here in Massachusetts. Larger cities as well, though, have passed ordinances like this. Seattle was the first. Seattle passed an ordinance like this, I want to say 6 or 7 years ago, and has been, implementing it effectively ever since. The city of San Francisco, a city of about the same size as Boston, slightly larger, passed an ordinance like this, I think last summer. So in any event, this is certainly a bureaucratic burden. We're not going to pretend that it's not on the advocate side. We do believe, however, that democracy requires hard work. We need to make sure that the city is implementing technology in a way that conforms with the values of the people who live here, and that procurement is not policy, that policy making by procurement rather is not happening exclusively in the executive branch, and that our elected leadership on the city's legislature, on the city council, can have a voice and can understand exactly what's going on in government to the collection of sensitive information about residents. So having said that, I've really, for those of you who are concerned in the administration about the bureaucratic burden that this is going to place on your agencies, I really would encourage you to reach out to officials in San Francisco, in Seattle, closer to home, here in Cambridge and Somerville, to get a sense from them about what it's been like. The Cambridge and Somerville ordinances are very, very close to the language that's before this, the council here in Boston. So, you could probably learn quite a bit from them about how implementation has gone thus far. The only other thing I'd say about that is that the city has 9 months to comply with the ordinance in the first instance. So it's not as if the ordinance passes next week, you have to have all your documents into the council in a week, a month, even 2 months. You have close to a year to comply at the outset. So we think that that's a reasonable amount of time, that should, provide the city with plenty of time to do its due diligence and get the information that you need to the council and to the public. The final thing I'll say about time is that the fact that this ordinance is concerning to the administration with respect to the bureaucratic burden it's going to place on your agencies, I think to me is a real indication of why this ordinance. That to me indicates that there's a lot of surveillance going on in the administration that the public's not aware of, that the council's not aware of. And that doesn't mean that those surveillance programs are inappropriate. It doesn't mean that too much information is being collected or the information is not being properly secured. Although if you'll review the testimony that the ACLU provided at the hearing last month, you'll see some examples of when in fact that has been the case. Like, for example, when the Boston Transportation Department accidentally left a whole database of license plate reader data on the public internet for the world to see. That's an example of the kind of abuse that we're trying to prevent with an ordinance like this. So, there's a lot of information gathering going on in government, and it's important not only for democracy and for privacy for people through the council to have an opportunity to engage with that process and to have some control over it, but frankly, it also, I think, will help government do a better job internally of making sure that accidents like that BTD, license plate reader data snafu do not happen. This is an important check, both internally in the administration and I think for the public, for all of this to go before the council. So I'll just say a couple more things. On the question of identifiable data, Chief Osgood, you raised that concern. We are concerned about the government's use of cell phone location data, for example. I'd like to know when my cell phone location data is being used by which city agencies for what purposes. And it absolutely is the case, as you highlight, that for example, cell phone location data could be used to identify me personally and to track my movements throughout the city when combined with my home address, for example. That's information that the council deserves to know, that the public deserves to know. We need to know how that information is being secured, where the city is getting it from, who has access to it, what types of controls are limiting that access, so that we can make sure that there isn't, a horrible tragedy that results from, someone inappropriately getting access to that information and using it for their own personal purposes, for abuse or misuse. So I think that's a really important part of the ordinance, actually. And I'll just close by saying, Nayeli, I hear what you're saying. I'm not sure what your title is. I'm sorry. So I'm just going to use your first name. I hear what you're saying about all of the work that the city has been engaged in terms of getting a sense internally on what's going on across departments. And I would just say that all we're asking for here is for you to share that information with the council. So it actually sounds like you've done a lot of this work. It sounds like you're engaged in a lot of this work already. What we want to do is bring the public and the council into that process and give the council and the public a chance to have some control over what's going on behind closed doors in the administration. So with that, I'll just thank you all. Again, I want to thank the councilors for all of the incredible work that you have done on this so far and for all your support. And I'll pass it over to Emiliano Falcon Morano from my office, who's going to talk through some of the changes to the language that the advocates have suggested. Thank you.
Thank you, Kate. Hi, thank you, councilors, for having us here. Thank you for the administration for coming to this working session. So now I'm going to speak about the summary of the proposed amendments to the ordinance that we all shared with you. So the system is like I will read the amendments and then the other participants in the panel will explain them. So first, we are proposing the replacement of the term VSP officer for the term school police officer throughout the ordinance. The second one is that we are proposing the including the word it in the exigent circumstances definition in section 16/63.2. So I am using the references to the red line that we all have, which is with the chapters of the Boston Code of Ordinances. The third one is an amendment of the definition of school police officer in section 1663.2. The proposed definition states that school police officer means any officials or employees that belong to the Boston Public Schools Department of Safety Services or any other security and enforcement personnel, and that may or may not be licensed by the Boston Police Department as special police officers. The fourth amendment is an amendment of the definition of student reports in section 1663.2. The proposed definition includes the possibility of student reports targeting all student activity, not only incident related, and mentions that these reports are all those reports that are not considered an educational record under FERPA, F-E-R-P. The federal law about education records. The proposed definition also mentions that informal emails, texts, and other electronic messages that describe or contain details pertaining to student activity are going to be considered student reports. The fifth one is the creation of a new category called historic student reports to name those reports created before the enactment of this ordinance. This is in section 1663.2 also. The sixth amendment is the replacement of the term seriously bodily harm with serious bodily harm in section 1663.2. This is because the term of art, there was a typo in the original ordinance. The seventh change is an amendment of section 1663.4a to read that school police officers shall only collect, store, or share information pertaining to students by creating and sharing student reports in accordance with this ordinance. The number 8 is an amendment of section 1663.4.8.1 to read that student reports shall only be created when, and then the circumstances where the student reports can be created. The number 9, change number 9, is an amendment of the language related to the residence of students in section 1663.4.8.3. The language proposed is broader and encompasses the address and or neighborhood of residence. Change number 10. Amendment of the language related to gang involvement in section 1663.4a3. The language proposed is broader and encompasses all the ways in which the noting of gang involvement can affect students. Change number 11. Suppression of the requirement that the category of ethnicity be not included in the student reports. As will be explained later, student rights advocates recommended that this category should be included and reported to analyze whether certain students from some ethnicities are more reported than others. Change number 12. Addition of new paragraphs 4 and 5 in section 1663.4a to clarify the roles of the principals and headmasters of the schools. These new subsections also establish a process by which they have to send a student report to the student and their family. Change number 13, amendment of section 1663.4b to provide for rules regarding the process of information sharing. A. School police officers and BPS personnel shall not transmit to or share with BPD or any other outside agency any information about students, including but not limited to student reports, through any official or unofficial channels, including but not limited to text, phone, email, database, and in-person communication. This is the general rule. Then the only two exceptions are when the transmission or sharing is done. First, pursuant to section 1663.4c, or in exigent circumstances pursuant to section 1663.4d. Change number 14 relates to these two previous sections. So there are the two new sections are 1663 4C and 1663 4D. These sections create a detailed process of information sharing. First, there is the establishment of two different frameworks for sharing information. And the first one that we can call an ordinary one that applies to all cases where the sharing of information is required by law or accepted by this ordinance. And the second one is when there are exigent circumstances. Among other things, the proposed language, first, shows that the explanation received by the students and parents should relate to why the student report is being sent to the Boston Police Department. It also incorporates the headmasters and the principals as an essential part of the process of information sharing. And finally, it ensures that the families of the students have participation in the process, even in those cases when there are exigent circumstances. The only change here is that when there are exigent circumstances, the family participation comes after the information was sharing, logically because of the existence of exigent circumstances. Change number 15. There is a new section, 1663 4E, that prohibits school police officers from attending any meetings where officers or employees from U.S. Immigration and Customs Enforcement, ICE, are present either in person or virtually. Change number 16. There are new representatives for the Community Information Sharing Board in section 1663 4G. The new language incorporates a parent or guardian chosen by the Boston Special Education Parent Advisory Council, a representative chosen by the Code of Conduct Advisory Council, and a representative of the District English Learning Advisory Committee, DELAC. Change number 17 is the inclusion of ethnicity in the categories of information that have to be reported to the board pursuant to 1663 4G3. This is the other side of the flip of the coin of the reason of why we took ethnicity from the student reports. Prohibition of categories. And finally, the change 18 is the amendment of section 1663(8) related to the implementation of the ordinance.
Emiliano, by any chance, do you have this as something that we could have followed along with on a screen sharing, or are these notes?
Yes, I think these were sent to you.
Okay.
It's the document is the list of amendments.
Okay, perfect. I'll forward that to all my colleagues.
Okay. Okay.
All right.
Great.
So that
yes.
we'll be following along. So thank you so much.
Yes, and there was one more thing, which this new section 1663(8) creates a framework for disposing and eliminating all the student reports, the historic student reports that do not conform with the language of this ordinance, while respecting the state law mandated retention of records. Yes, I think that this. Thank you, Chair. I think that this document was sent to you. I can tell you that.
I just got a text message actually that it was sent in advance, so all of us have it in our inboxes.
Yes, I can tell you if you want the name of the document so that you can find it. 1 second. The name of the document is Substantive Amendments to 0684. That's the original document that I was reading.
Thank you so much.
The only thing is that I changed the references to the chapters. In that document, you will have the references to the ordinance, like section 1, section 2, section 3, and this is the final red line with all the formats included, all the format changes included. Sorry about that. Thank you, Chair.
No, you did an excellent job. I forgot to announce that it had been sent around. My apologies, and thank you so much for your thorough. You came here to work in this session. Thank you so much.
Thank you.
And I do appreciate, by the way, for the administration who pointed to specific sections that were concerned about the practical implementation. I really do appreciate that as well. Is that are those the edits, or is that the substantive testimony from the ACLU?
Yes, that's yes, that's a list of amendments, and then the other members of the panels will dig deeper into why this amendment are needed. Thank you so much, Chair.
Thank you so much. I think we went from ACLU to, I think it was SIM. And then if there's testimony from SIM.
Chair Campbell, would it be, excuse me, Chair Edwards, would it be all right if Elizabeth Badger from Pear went next?
If you guys have an order, feel
Okay.
free.
Great.
So go ahead.
Thank you.
Hi,
Hi,
Elizabeth.
good morning, Elizabeth. I'll be brief, and I think I'm more interested in addressing specific questions or issues with specific provisions. Really quickly, I think the first gentleman who testified, I just kind of want to address a broader policy concern, mentioned the need to have that some of this language would slow down responsiveness. And I would just like to suggest that I think that's exactly what we're looking for. The data sharing that has occurred that we've seen through document production from the police department and the Boston Public Schools shows that data sharing between ICE and the BRIC in the schools has become completely unregulated and without any attention to the law. And so we need it to slow down and comply with the law, and that is what this ordinance proposes will happen. I've yet to see a single communication where an urgent situation was dealt with. It is generally of the nature of digging for information to criminalize Boston Public School students. And I have not seen, as I said, a situation that required urgent communication between those agencies, BPS, BRIC, and the ICE. Emiliano mentioned a few provisions regarding historic information and how the city should address those historic reports, which I think is what folks were interested in me addressing. So I'll try to do that briefly. We become aware through our own practice as immigration advocates and through document production that there are large chunks of, I don't know, intelligence reports, face sheets, write-ups, whatever you want to call them, produced principally by Boston school resource officers. And the city has yet to address where those historic reports are housed. It's been suggested just in people's emails on maybe, Google Drives that people have created. No one seems to be sure. And so the section, and I want to get it right, 1663.8 addresses what the city should do to gather those historic reports, see if they comply with the ordinance and timelines for those documents or write-ups, again, or whatever you're going to call them, be destroyed so that we are not concerned about historic reports prejudicing and criminalizing students further than they already have. The one other provision I'll briefly address is the meetings. We become aware that there are monthly meetings between BRIC, ICE, Boston School Resource Officers that did go virtual at one point. We're not sure if those meetings are ongoing. We've never seen an email more monthly meetings with ICE or no more texting, emailing with ICE. So until we see those communications go out from BPS, and even still, we are asking that through the ordinance that it be made clear that school officers should not be meeting regularly with the BRIC and ICE as they apparently have been doing for several years. So again, I'll turn it over to my colleagues, but I'll be happy to address any specific questions that the counselors or other panelists have. Thank you.
Thank you. After pair, is there a preference in order? If not,
Oh, I was just going to say that if Liz also doesn't have anything, we will hold our comments until later in the session.
Or Sabrina, do you want to talk?
Yeah, sure. I'll speak to a few amendments that really stand out to me. So, hi everyone, my name is Sabrina Barroso. I'm the lead organizer for the Student Immigrant Movement. So like I mentioned, particularly for me, some of the amendments that I would like to speak on today are, for me, these go together, number 7 and number 13. Number 7 says amendment of section 1663 4A to read school police officers shall only collect, store, or share information pertaining to students by creating and sharing student reports in accordance with the ordinance. And 13 being amendment of section 1663 4B to provide for rules regarding for process of information sharing. For me, they stand out because like my colleagues have mentioned and my other partners in this work, this process of information sharing has been completely unregulated and is completely immoral. One, for the protection of our youth and for our families. So when I read number 7 in regards to that school police officers shall only collect, store information or share information pertaining to students by creating and sharing student reports in accordance with the ordinance, it's that, for example, we've seen reports and communication that happens and unfolds informally through email without there being a report that is written. There will be information shared about a young person, about maybe what they're wearing, a whole variety of things that are being reported on without a formal report being written if the situation is that serious, right? So this type of information sharing is completely wrong to do in the first place. And then in regards to 13, to provide rules regarding the process for information sharing. So this more directly talks about how the process of sharing would be happening. So like Elizabeth Badger had explained, right? Like, and how I was just talking about this whole informal process, there needs to actually be transparency and accountability for the type of information that is being collected and shared, right? So this is not only limited to, right, like phone calls or text messages or putting it on a database, right? We're talking about there should not be any transmission or any information shared with BPD if it does not go within the guidelines of this ordinance for when a report should be made. In number 10, it says amendment of the language related to gang involvement in section 1663 4A3. For me, this is very personal because I have seen where school police officers in reports will claim gang affiliation or claim that a young person is a gang member. And I'm sure that many of you all here have heard of the gang database and the point system that is tied along with this gang database. Young people are literally being criminalized when there's no real evidence to be used against them. They will acquire points when a school police officer calls them a gang affiliate, right? So by no real evidence, just someone saying, oh, I believe this person is a gang member, right? You are literally damaging someone's life. And we have real evidence to show that this has negatively impacted the lives of young people. So, you know, this is very, very important language that must be included, that must be written out so that it's no longer a practice. And we know that this happens. We know that young people are constantly being referred to as gang affiliates and gang members. So there really does need to be a serious conversation, or in regard, right? Like there needs to be written language that finally puts it very clearly that you cannot be calling young people gang members or gang affiliates like this. Number 11 says suppression of requirements that category, so not using ethnicity in student reports. And so this is happening in the sense of how the term ethnicity can be used circumstantially. So for example, there are white Latinos, right? The same way that there are Black Latinos, there are people who look like me who are brown, right? So in using in using ethnicity in student reports, right, it might be so that it can be skewed. So where there are many white passing Latinos, they might be written out as white. And again, right, this can skew the actual way we are analyzing this data. And this ties into number 17 with the inclusion of ethnicity to be included in the categories that are reported to the board pursuant to 1663 4G3. And so including ethnicity for what will be analyzed in the board is a way of actually being able to analyze this data as a more inclusive scope, right? So not just being able to like tag young people based on the report that is written on them, but having this information for the board to review. And then in 13, oh wait, no, I already spoke about this one, my bad, y'all. And then, so for 14, new section 1663 4C and 1663 4D that creates a detailed process of information sharing. And this was what Emiliano had spoke on, where there would be 2 frameworks, one that is for things that are mandated by the state, things that are required by law, and then the other for exigent circumstances. For me, this is also very important because this is, like I was mentioning before, about accountability for the type of information that is collected and shared, right? So right now, there was, like, up until, we started this conversation, there was no transparency or involvement of families and the young people involved. So reports would be made and stored and shared, and young people and their families would have no clue that these reports were being written and shared with the BPD, and then in turn criminalizing them. So using this proper language to be able to speak about one, being able to have this information be shared with the students so that they understand what is happening, what report has been shared, to who it has been shared, incorporating headmasters and principals to make sure that they are fully informed and aware and are an essential piece of this process. And then also being able to, like I'm saying, including families and the students in this process, because especially during exigent circumstances, right, where, it's only right that families are informed if the school system is sharing their information with other agencies. It's only right. And so, yeah, these amendments personally stand out to me, are very important to me, and the work that I've been able to do through my own personal lens, and then speaking in the lens of an organizer. For far too long we've been having these conversations, and it's imperative that we finally put strong language to protect young people. It's not okay, right, for any of this to have happened in the first place. And so this type of language, if we really do agree on protecting young people, this is the only thing that is right, for us to be able to have strong language that will finally put in place order in regards to private information. So thank you all for hearing me out.
Hi, I can talk next. Good morning. I have to apologize. I'm going to have to go at 11:45. I was only able to take personal time during my prep time and my lunch, and so I have to go back to teaching. And so because this was scheduled during the school day, I'm sorry that I won't be able to stay, because I was really hoping to be part of the discussion on the language. So I'm going to just talk very briefly. I want to address the fact that BPS has a similar policy. Myself, Valeria, Elena, Elizabeth, and Liz were all part of the process of creating it, and all expressed our concerns numerous times to Mr. DePina and the rest of the BPS staff around our policies, and we sent a document that hopefully went out to all the counselors comparing the two policies and how how the BPS policy really does not fully protect the students in our care. If you'd like me to talk more about that, I'm happy to when the time comes, but hopefully you've got that policy. I just want to talk about a couple more amendments. I want to talk about, I think that number 9 talks about putting into what can't go into report the address or residency, and that came to us from members of BSAC who spoke very specifically about not wanting their address shared with the police or being given out so easily. That goes to their protection and their safety, and the safety of their families. And especially if you think about the huge number of mixed status families and undocumented students we have in our city, the idea that the police, which we know are communicating with ICE, can get the address of a student is frankly terrifying to students. In section 12, one thing that we tried to do is really also address what happens with schools that don't have school police officers. I know that only 55 of our schools do have it. So if what are the regulations on headmasters, heads of schools and principals as they communicate with the police, because we know that there are many. I know that there are floating school police officers that do come in, but also sometimes that heads of schools are talking directly with the police. And so adding that information and also establishing a framework. Number 14 is establishing a framework for exigent circumstances, because we realize that there's times when there's an urgent situation and you can't have those conversations yet, but still making sure that families are informed that we're centering the students and their families in the work that we're doing. And finally, I think Elizabeth talked to section 15, but making sure that our school employees are not in regular meetings or in conversations with ICE officials, I think is very important. And I'm happy to answer any other questions. And then I think Liz is next, and then I think we'll be done.
Yeah, thanks, Nora. So I'm Elizabeth McIntyre. I'm a lawyer at Greater Boston Legal Services. We represent low-income young people of color in school discipline and related special ed cases. So I'm here mostly to talk about the BPS portion of this ordinance. And I wanted to just touch on a couple of amendments. One is in section 5 and point out sort of some of the differences between the policy that BPS has just passed and what's proposed in this ordinance. So one is in section 5.1.1, where we're talking about under what circumstances student reports or BPD 11s can be created. So the current BPS policy here allows for 11s to be created in cases of just assault and battery. Assault doesn't even require any kind of, physical contact. So for example, like I represented a student once who she was 9, she was running, she knocked over a chair and the chair landed near a school police officer and a report was generated. So that would still be allowed under Boston's current policy, but not with the language here, which instead of thinking about this in terms of criminality, as in, is this a felony? Is this a misdemeanor? The language in this ordinance really looks at like, what is the harm that was done and how, what is the purpose of writing a report? I think that's one important change. I also, Sabrina talked about this too. I think it's important and affects a lot of our clients is the suspected or alleged or confirmed gang involvement, and whether or not the confirmed gang involvement can be included in a 11. So again, under Boston's current policy, alleged gang involvement is prohibited, but confirmed is allowed. And one thing that remains really unclear is like what it means to have that be confirmed, and to what extent confirming that is going to cause the exact kind of conversations that we're trying to prohibit here. So in order for a Boston school safety officer to confirm that a student is, you know, a gang member, perhaps that officer then calls a BPD officer, and then they have this conversation that the ordinance is trying to prevent. And then lastly, I want to point out the part that of the ordinance that talks about the requiring communication between a school safety officer and the head of school, which we think is really critical. You know, I had a case where a young man who had a developmental delay, who became escalated in sort of the common area of a BPS high school. And while he was escalated and he was with a paraprofessional, he said that he was going to bring the ocean in to flood the school and kill everyone in the school. And the police officer heard this and wrote a report. He ended up having to go to a clerk magistrate's hearing. There was an open CRA. It became this just, and had the officer talked to the head of school, they would have known, like, no, he has an IEP. Like, obviously, he can't bring the ocean to flood the school. This is not a law enforcement issue. This is a special ed issue, and it could have been resolved. And instead, it became this incredibly traumatic event in this child's life. So the idea is to try and make sure that school police officers are talking to heads of schools who know their students and who are in the best position to, you know, help inform what the next step should be. So I'm going to leave it there so that we have some time for discussion.
Thank you. Valeria, did you want to say something as well, just to make sure that we had?
No, I think we should head into a discussion. Mostly, I think too, like, just want to agree with the points made that we think that the current BPS policy, which was, you know, in many ways influenced by our advocacy and led by our advocacy, still does leave out a lot of, remain a lot of concerns for us, especially what Liz just mentioned, like the lack of conversation and involvement of the heads of schools and putting school police officers in the position to determine what is the activity or what is the way that a student activity should be categorized, when clearly that's what we have things like code of conduct for, and that's why we have heads of schools for. So I think we'll talk more about those things, but I think we can move forward.
Thank you very much. So what we'll probably do now is go in order of arrival, starting with the co-sponsors for suggestions, concerns, questions about language specifically in the ordinance. And what I would really try to do is keep my colleagues in line for moving forward the conversation. I will say for the administration, thank you so much for kind of summarizing some of your concerns. I did find the letter, and there was no real citation to the charter or to what made the overall issue of it unconstitutional. It just was, there's concerns. And so I appreciate those concerns, but I think if there's a genuine, I don't want to call it an olive branch, but a genuine attempt to move this conversation forward, as everyone from the administration testified, they're excited about moving this conversation forward, excited about having it, then I really think there should be a genuine attempt to talk about the language and to provide a markup of the concerns of the language and provide alternatives for that language. I think that would indicate to me there's a real want to move this conversation forward, and it's worth either having subsequent working sessions and looking into the new year for passing this. But if there's no actual push, concern, or written suggestions, I mean, we just heard about a lot of them for the first time today, or concerns, then it really does make myself and possibly some of my other colleagues wonder if there's a genuine want to do this and get this done. In short, put up something so we can continue this conversation. But if you don't, then I think the conversation will have to go without you. And I don't want that. So, so I'm going to turn it now over to my colleagues, the co-sponsors and my colleagues to ask any questions that they have. Some of my colleagues had to leave early and they'll submit them in writing to me later. But I want to thank them all for coming. So Councillor Wu, Councillor Arroyo, and Councillor Janey first with any questions, suggestions, and then we'll continue.
Thank you, Madam Chair. I don't have too much to add. I was going to say everything that you just said, which is that we didn't hear very many specifics today in terms of what changes might be proposed. And it feels, to be honest, like a very familiar conversation that could be applied across nearly any of the ordinances that we have been working on over the last many years that I've been at this. So it's really at the stage now where this document comes from, as you've heard, a very well-researched, comprehensive, significant amount of time from all of the advocates working with other municipalities who have already implemented this. So some of the more vague concerns about legality and implementation, we have wrestled with, and we have thought about very carefully and included language that builds on the experiences of other municipalities, including in Massachusetts, who have already done this. I know we've been through this before with many other ordinances where there is a period where it comes down to, at some point we just have to sort of call it. And then at that point, often there will be more of an agreement to then submit changes that are more significant and tangible. So I'm looking forward to getting to that stage, because I think we still need to recognize at this moment that we are in as a society, as a city, is one where we cannot afford to continue delaying on important conversations and taking action, because we know what happens when we delay. We know there are consequences that continue to accrue to Black and Brown communities, to our students, and we have put forward very specific protections and critical changes that are time sensitive. So that's all I had to add. Thank you very much.
Thank you. Councillor Arroyo.
Thank you, Madam Chair. I would just echo, I think we have, I didn't count, but I think it's about 6+ members of the administration here. We had none for the hearing, and many of the administration, since I've been here for these ordinances, treat working sessions like their hearings. They stonewall them. They speak about things that should have been spoken about at a hearing, their concerns, their thoughts, the things that they think about without any, and which, by the way, I'm happy to hear your concerns and your thoughts as it applies to the language that we've written, not as it applies to general principles of, things you would speak about in hearings about the legality and all this other stuff when we don't have a lawyer here represented by the city to even speak to that. So, the reality for me is I stand by this ordinance. I think it's closely crafted to the language we want it to. I think we have to recognize in the world that we exist in now, surveillance is becoming a much more day-to-day need and concern for people. The city is using surveillance and technology in ways that I think it may be, arguably productive and helpful, but also the residents have a right to know about that and how that's being applied. And so for me, I'm happy to hear any questions or any direct references to language. And I want to just say that I saw Chief Osgood had some direct reference to language, and so thank you for that. But I'm happy to hear anybody who wants to speak directly to the language. I don't have much else to say. I said everything I had to say at the hearing. And so I stand by this, and I appreciate people who are here today to work.
Thank you. Councillor Janey.
Thank you so much, Madam Chair. And I would just echo the concern and disappointment of my colleagues in terms of where we are in the process. I appreciate, all of the comments that have been given during this working session, but my concern is that it is not moving us further along in this process. The letter was sent prior to our hearing, which we did not have representation from the administration attend the hearing, and the letter again made vague references to legalities and coming up against the charter, but doesn't cite what the actual issues are. I was hopeful that this working session would uncover some of that if there were in fact legitimate concerns, that we would be able to discuss it here. That is not the case. I am grateful to the many advocates who are on the call who continue to do the work. And so thank you for your work on the original language, but also, you know, as we work through this process, this is what a working session and having this ordinance, you know, moving through the city council is our opportunity to make sure that the language is exactly how we want the language to be. And so advocates continue to work on language, and I appreciate the amendments and the master copy and all the documents that we have. I guess the one question that I would leave for the administration, having heard some of the amended language and having heard from the advocates who have been at the center of this, is there a response? So sorry, is there a response from the administration directly to the advocates on some of the language? If not, then again, I don't want to take time here because the whole goal here is to kind of get down in the weeds of the language. We want to make sure that we are producing a final document that will come before the city council for a vote and before the mayor for his signature. So if there's a response from the administration to the advocates on what the advocates have shared in terms of additional suggested language, I'd be interested in hearing that response. If not, I'm hopeful that we will be able to, through the committee, continue to work on this important ordinance. Thank you, Madam Chair.
Thank you. Anybody from the administration on any of the thoughts, or because I know the advocates did get to respond to some of the thoughts and concerns from the administration. Does the administration, and I forgot to ask that, anybody?
One really quick one, Councilor, and so I think I actually really appreciate it, and I think I totally agree with the issues that Cade raised around the definition in 1.3. And so the issue is, I think, not the way in which the definition is shared, but because so much of the there's potential data that is collected that is not anonymized, that when it is combined could be de-anonymized. I'm not sure that, and I might be wrong, but I'm not sure that the current ordinance as drafted actually really wrestles with that. And I think that might be in section, I could be wrong, but it could be in section 3.3 in the data access provision in there. I think that you'd want additional language to be able to address that, or it's something which needs to be amended in our existing open and protected data executive ordinance. So there's some routes to go, but I actually agree, Kate, with the issues that you flagged. And the issue was not to adjust 1.3, but it was to figure out, like, we do not intend it with so much of the mobility data to actually have personally identifiable information, but I recognize exactly the issue you flagged. And I don't think that's exactly covered in this ordinance as written, or I might just be missing how it's covered, how it's addressed. I don't know if Nigel or Chris or Nayeli have other thoughts on that as well. Or Kate, sorry.
Chair Edwards, is it okay if I respond to that?
Yes, and then anybody else in the administration, actually, before you respond, let's just, if there's a comprehensive from the administration, Kate, just to make sure that we hear all the.
Sure, I'd like to, at some point, I can wait for the appropriate time.
I'm sorry?
Waiting for the appropriate time to respond if I could, so I'm just waiting to be called on. I'm not sure the order here, so if I can go now, I can address some of the points that were raised. If not, let me know when's the appropriate time.
No, it's appropriate now. Kate, we'll just wait. I think we should all just wait for the administration to respond. So go ahead.
Okay, yeah, thank you. I mean, I think for me, regarding the language, our policies, the policy that we passed, to Nora's point earlier, doesn't capture a lot of kind of the spirit of the ordinance, and clarify that we do have procedures in place according to the policy of how information is shared, and I believe ours is more restrictive. And again, it's already in place, right? So the only people that can share information outside of the Department of Safety Services is the chief and deputy chief, and that's only to the Boston Police liaison, to the school unit liaison, right? So that's the farthest extent it goes, and no individual officers can share any information outside of that process. And we've tightened that up with this policy. I also want to call out that the heads of schools are now required to have these conversations prior to any incident report being written, and have those communications with the families in order to make them aware of the incident that occurred and why a report is generated. So I mean, my suggestion would be to, adopt the language that we have in our policy because it's already passed. It's already a policy in place. And we've had a lot of discussions with a lot of the advocates and partners here at the table. We've had months and months of conversation, and for a variety of reasons, we landed on the policy that we have now. And we recognize the fact that there is a need to maybe go further and broader. But as of now, this is where our policy stands. And we have created a forum by which we are going to continue to engage in conversations, monitor the data as the policy is written. And once we get a chance to analyze the data with the policy is currently written, we are open to making more changes to it. So our position is for us to maintain our policy and let our policy be the guide and drive to any broader ordinances. But again, that's our suggestion. The policy has been in place, and we're working on implementation and training and data collection. And based on that information, we'd make any additional changes to the policy.
Counselor Edwards, I know that you wanted all the administration's questions, but I have to go to class in 3 minutes. Could I quickly respond to Mr. DePina's comment?
Sure.
So I recognize that, yes, it talks about information being shared just from the chief of police, but what my huge concern is the writing of BPD 1.1 reports, which is I'm forgetting the word, is made institutionalized through this policy. And those reports go directly to BPD. And you have told me in numerous meetings, I mean, we've had this conversation for over a year now, that those reports go directly to BPD and that BPS no longer has access to them and does not know how many reports are going to BPD, what those content of those reports are in. And so one of my huge concerns, and I said this in our meetings, we went round and round about it in the working group. I said this at school committee, is that the bar for what can be written as a BPD 1.1, a report that leaves the BPS's hands, is too low. And Liz McIntyre gave some examples of what that is. And so, yes, there's really restrictive of who can call and who can email. And I'm curious about how you are going to be tracking that. But what I'm more concerned about is that police reports are written with no oversight. And there's the heads of schools get to see them, but they don't get to say, this incident doesn't require a police report and shouldn't be reported. They don't have oversight of it. No one has oversight. And these are reports going straight to BPD. That BPS doesn't frankly know how many of those reports have gone in the last.
So if I can respond briefly, so prior to this policy, that communication did happen informally, but our current policy that was passed in September requires those conversations to happen and those discussions to be had prior to any reports being written. So the school administration does now have.
I'm sorry to interrupt. I actually have to leave. Hopefully other people can respond.
We can agree to disagree, but I think respectfully, our policy addresses all the matters that you've referenced.
Can I respond?
Well, first I want to say thank you to our unafraid educator who is now going to educate our folks and doing her wonderful duty as a teacher. So she may be gone already, but I want to say thank you so much for that. Yes, Councilor Arroyo, please respond. And then I do want to get to Councilor Braden, Councilor Sabi George, and Councilor Bach.
Thank you so much. I just want to respond to a couple things. One, right before this hearing, I'm not sure how much earlier in advance it was sent, but we got the responses to questions that were asked during the education hearing, which was held the same week we held this hearing regarding this ordinance where the administration did not show. And we asked questions about BPD and BPS's involvement in BPD 1.1 reports. And even in the response that was sent to us about how many, it's clear, it says in the actual report, BPS cannot, I'm quoting, BPS cannot determine an accurate number of reports written by BPD officers. It literally says it in the report. So, I mean, that's from you. Thank you. I appreciate it. It says that you cannot do it in your own writing. That's not opinion. That's not that's not, anything beyond that. I also remember that I asked in that hearing, and there's footage of this, I asked in that hearing whether or not an administrator could stop an officer, a school officer, from sending a report. They're not allowed to. They're actually just consented. There's actually nothing that says that an administrator can tell a BPD officer not to do that and that it is binding. There's nothing that does that. And so, I appreciate that the intent of the BPS plan was to protect children and to deal with loopholes, which, by the way, they should have, because BPD was reacting and speaking to BRIC and sending things to BPS, and those emails and all those things that happened required this response. So the response was appropriate. The issue is it doesn't go far enough. And so when we talk about, the administration has a say, they have no say. They get informed. There is no say. And so if you just inform somebody, we're thinking of doing this, and I can say, no, don't do that, and you can still do it, then that's not a check. It's not a check. And so I recognize that, we're having a discussion about what BPS's report did, and I recognize that you're here essentially to advocate that what BPS did is far enough and we should give that a chance. But the reality is there's huge holes in what BPS did. There's large holes that allow for the furtherance of sending data to BPD, which then allows it to be to BRIC. And then the reality is there's nothing in this actual ordinance that makes it looser. This only tightens protections. And so unless we're saying that there's such thing as too much protection, I don't actually know what the point of saying BPS already did something. Well, this goes further. And so unless you're saying we shouldn't go further to protect children, I'd like to hear why we shouldn't do that, because I haven't heard that yet. What I've heard is we already do this. Well, we don't. I wouldn't have put in an ordinance if we already did it. So what is it that BPS thinks we should do? Does BPS think we shouldn't go this far to protect children? And if they believe that, why?
Councilor Roy, our position is that we have looked at the issue. We've engaged in conversations, both with partners, family stakeholders, and developed a policy. And with that input from all the stakeholders that I mentioned, we developed what we believe is a safe and just policy that will protect the student information. And we also follow our FERPA requirements with regard to that. So I welcome the opportunity to have any measures that can further keep our children safe, but there are also, requirements that Boston police have and school police have of writing reports that we can't ignore, right? So our policy does call out the fact that, we want to decriminalize a lot of misdemeanor behavior. It does call out the fact that we want to ensure that any student discipline related matters of misbehavior are treated as such. But unfortunately, when it rises to the level of felony crimes, assault and battery, hazing, and other incidents that require police intervention, we're going to pursue that in cases to keep families and victims safe. There's also the victim aspect of this whole thing, right? So a lot of people are victims to some of these crimes, and these victims also want to pursue legal action, and these victims also want to be protected and kept safe. So we believe our policy balances any potential perpetrators, as well as make sure that victims of these crimes are safe. So again, our position is that we have a policy. I appreciate to see that a lot of what we've written is incorporated in this ordinance. But again, our position is we want to see the policy as we've written, implemented, discussed, data analyzed before we make any further changes.
Before there's any other back and forth, I want to acknowledge that we've been joined by Councilor Flynn. He has no opening remarks. He's listening and questioning it, listening and taking notes. I do want to get to the other councilors who have been patiently waiting. I do know that there will be some other responses to this back and forth, but out of respect for my colleagues who've been waiting, I'm going to move down the line. Councilor Braden and Councilor Sabi George.
Thank you, Madam Chair, and thank you to everyone who's participating this morning. There's a lot to unpack here, and there's an incredible amount of discussion about BPS, and rightly so. It's an area of great concern. I'm a little concerned about the broader surveillance implications that go beyond the schools. think I echo Chris Osgood's, concern about merging of data. I'd love to get my head around broader surveillance applications and what they are and how they're being used in the city, and how that information has been shared with state and federal agencies and authorities. I think it's almost like we've got two buckets here. We have very specific concerns, and it seems like 90% of the conversation this morning has been about schools and what happens in schools and how things are reported in schools. And for me personally, having grown up in Northern Ireland, which I would call a police state, I think surveillance, the broader discussion about surveillance needs some more attention as well. So that's more of a comment, and I'm trying to just unpack all the information. It seems like if there are holes in the BPS new regulations that they have come forward with, then perhaps this ordinance would be specifically targeted at addressing those deficiencies. But I think in the broader context of surveillance, and I don't think we have done a deep enough dive into that conversation this morning. Two different buckets, I think. I'd like, a deeper dive into the broader surveillance issues that we haven't addressed this morning, and in terms of the broader population. I know it's been a very good conversation about the school situation, but that's my 2 pennies at the moment. Thank you.
Appreciate your 2 pennies. I would say they're at least worth 2 quarters. But I do think, and what Councilor Braden did note is that there's 2 major veins of this legislation. One is directly dealing with BPS and its transfer of information, and the other is overall surveillance technology, and having to present that to the council, having to present that basically to the public, what we invest in and how we are watched in all forms, and making sure there's a process to be totally, completely transparent and accountable to the public. I want to be clear, none of, and the co-sponsors can correct me, this legislation does not ban surveillance so much as it requires that we are transparent about how we are watching everybody and who we pass information to. So that folks are concerned. I know some people are concerned about, like, oh, this practically does this or does this. There is no ban, because we, and I say this as a supporter of this legislation, but as a council and as a understand surveillance may be necessary sometimes. I just want, and I think many people do want, a process for which we are completely transparent to the folks of Boston about how that surveillance works, how much we invest in it, who is doing it, and where the information goes. So just wanted to thank you, Councilor Braden, Councilor Asabi George, and Councilor Bach.
Thank you, Madam Chair, and thank you everyone who is here with us today. I think this is probably maybe a little bit of an extension on Councilor Braden's questions, but what departments and applications would this ordinance cover? Because we have talked a lot about the Boston Public Schools, certainly the Boston Police Department. Are there other departments that would be directly related to this ordinance or need to be responsible to this ordinance?
Just quickly, as the chair election, every city department that does any form of surveillance.
But so that's transportation, I imagine, BTD. I guess the better question might be then, does it exclude any department? Is there any department that isn't participating in any sort of surveillance?
No. And by the definition, no, of surveillance, no.
So what is, so I'm curious, and maybe I missed it in opening remarks, but the Boston Public Library is here, for example. What is the impact on BPL? Is that cameras that are in our libraries? Is that sharing information about who has a library card and what books they're taking out? I want to understand sort of the fuller impact of this ordinance on all departments. I've spent some time in the weeds on the schools piece in particular, but not so much in some of these other areas. So I am very curious as to the impact that this would have on a variety of departments in the city, but also, any limitations that this may put on day-to-day business. So I don't know if anyone from either library could speak to that, or David through.
Thank you, Councilor Sabi George. Each of the departments had initially spoke to how the practical implication of this ordinance would impact the way they their day-to-day. And if they basically, it impacts them if they're surveying people. It doesn't require surveillance. It doesn't reduce their surveillance. I would say I overspoke a little bit when it comes to BPS. We do have limitations on that. But when it comes to outside of BPS, this is really a burden on them to report what they are watching, to report the information that they have, and to make that clear to the public. And if they acquire any additional technology to survey the public, that they are also transparent with that. This ordinance has a 9-month build out so that the reporting, I guess even the accounting, I don't expect every department to understand or know what they're watching and how often they're watching it and where that information is going. But that's the goal of this overall ordinance is not to add any additional. It's to say everyone come forward with what you are watching. And it would take a lot of time. And so as they testified, for many of them, it would impact some of their deadlines for RFPs, some of their day-to-day impacts on the time it would take. Doit mentioned it doesn't have currently the technology right now, and it would require a build out. So we went through the very many stages of those things, but ultimately the goal is not to add anything. It's more to say, what are you watching?
My curiosity there would be on any of the unintended consequences that we're not prepared for. I think that there are so many unknowns here, and that's part of what is I think creates some fear around this is that there are a lot of unknowns, but identifying them and appreciating sort of the unintended consequences while drafting this and sort of working towards a solid ordinance that would withstand sort of the challenges of those unintended consequences and still live in the spirit of what we're trying to do here. Thank you, Madam Chair.
Thank you, Councilor Sabi George. Councilor Bach, then I believe Councilor Furdy may have had to step away. So if he is gone, it will be Councilor Mejia after Councilor Bach.
Thank you, Madam Chair. And I'll have to ask forgiveness. I have a noon, which I'm going to be a little late to, but I won't be able to stay for the further conversation. A couple of notes from me. One is just, I think Councilor Sabi George just raised a bunch of the, potential implications for our departments, and we heard that from the administration at the beginning here. And I agree with Cade that I'm both encouraged to hear from Nayeli about the work that the administration is doing internally, and also feel like, it's time to unite those conversations. And I find that for me, looking at this legislation, I think that there are good democratic accountability reasons for us to pass a piece of legislation like this. And I also think that the city is very complicated and has a lot of data and surveillance work ongoing. And of course, the ordinance that we pass has to be sensitive to the nature of that in a bunch of departments. And I do take President David Leonard's point, Madam Chair, that in addition to the constraints around schools, I think he was pointing out that there's some areas of jurisdiction for the trustees of the library that are somewhat distinctive when we think about departments here. And so I'm very open to us sort of figuring out how to make this oversight legislation harmonious with these different concerns. And as somebody who was formerly in the Housing Authority, I'm very sensitive to the RFP dynamics and the fact that RFPing is how we do a lot of work in the city. And we can't have a piece of legislation that doesn't contemplate that and think about, to Chief Osgood's question, is this something where the council's evaluating things before RFPs even go out, in which case we're sort of pre-deciding what kind of technologies can bid, or are we doing it after? And then how do we work that with kind of the regulations around accepting a bid? But these all seem to me like soluble problems. And I think the thing that I would say to the administration is, I appreciate everybody's coming and saying that they agree with the spirit of the legislation. I think that we need to move to the next step where we say, yes, we're doing legislation. This is a thing that's happening. And so, you know, to Councillor Wu and Arroyo's point, let's have a markup. Let's sit down and hash out the departmental implications. Let's, you know, come to something that is going to be workable for our departments. But, you know, in the sort of this is a silly analogy in my head, but, you know, in the world of improv, part of making the thing work is to say yes at the outset to the concept. And I guess I'm asking the administration to say yes to the concept of not just the values here, but the concept that we are going to be legislatively involved as a council because of that democratic accountability piece. And so I would really like us to be looking when we are next talking about this and soon at, you know, markup of the legislation, at things like, you know, what the administration can share about the internal review that it's been doing and the principles that drive that, and kind of really getting down to brass tacks here, because to me, we've got to do this legislation, but I also, I would acknowledge the city's very bureaucratically complex. I do think we are another level of complexity above our neighbors to the north. But I don't think that that's a reason for us to wave our hands and say we can't have some kind of accountability like this here in Boston. So that's sort of my headspace on this. And I'm really grateful to everybody who's come today and to the advocates who've done so much work drafting and also with the substantive amendment proposals, and to the administration folks for showing up and giving the departmental perspectives today. And I think it's just kind of taking those to the next level of where does that cash out language wise. So definitely here for that conversation, and sorry that I won't be here for the rest of this conversation today. Thank you, Madam Chair.
Thank you, Councillor Bach. Councillor Flaherty is still here actually. So Councillor Flaherty.
Thank you, Madam Chair. Obviously, thanks to the administration officials who are here, my colleagues, of course, the advocates for their great work, and also for you, Madam Chair, for this working session. And to echo many of the sentiments of others, as a body, we certainly want members of the public to have a clear understanding of how their information is being collected and shared, specifically referring to the proposed amendments about the sections that are relevant to the BPS, school police officers, school resource officers, etc. We all agree that students in our classrooms should be able to be children, and that our school leaders and teachers should play a role in disciplinary actions and reports wherever appropriate. That said, obviously, I still have a number of questions similar to our colleague, Council Braden, and her reference in terms of unpacking this. But you know, I've heard about some implications with respect to the RFP process. So I'd love to have the administration maybe speak more to the implications budget-wise. And you know, obviously, I put my sort of fiduciary responsibility hat on, and we only have a couple weeks left in the legislative session, and thinking about the potential budget impacts it will have on a variety of different departments, many of whom are represented here by their respective department heads. So I think it's sufficient to say that, you know, we need to really have an understanding of what these implications are for the RFP process, and what if any burdens will be placed, budgetary burdens will be placed on these departments with respect to sort of their day-to-day operational impact. So I'd love to have something on that front. And then just maybe more from a housekeeping standpoint, what if any action is to be taken now? And is this something that is going to require in either another working session or more meetings of the minds in the first quarter of 2021, just for planning purposes through the chair?
Thank you. So in terms of planning, I'll just be transparent. I'm going to speak to the co-sponsors of this legislation, as well as advocates, and hopefully the administration is open to figuring out if there's a way to land this plane this year. And if not, I really would like some firm indication from the administration if there's a yes in there, and how long it's going to take them to fill in those details if we're going to push this to next year. But it's really the administration's kind of push to say it's a yes, but within X amount of time, and yes, there's a commitment for us to put the work in to get to that. So I want to be clear with that, and also the co-sponsors and the advocates, because I don't want to ignore the work that they did, which was a lot and extensive over some time. And this isn't the first time we've had a surveillance ordinance or a hearing about it. So there's been conversation going on. To say that we want more conversation is nice, but I need a commitment that there's going to be a landing of this plane. In terms of the question about the RFP, I think it was Chris that brought it up, or I think it may have been actually Nayeli maybe who brought it up. If you could kind of respond tangentially, specifically to Councilor Flaherty's concern about the RFP and budgeting, and also as this has come up, if the advocates for ACLU CADE want to respond as well to the RFP question, that would also be extremely helpful. So.
Sure, thanks, Chair. I'll just say something quickly, which is that the ordinance as written would allow for the city to put out RFPs without coming to the council first. It would merely require that before the city enters into any arrangement to acquire a surveillance technology that the city does not already use, that hasn't been previously approved, that the technology be approved by the council. So I think maybe an example of why this is important would benefit the public as well as the counselors and the folks in the administration who are listening to this. Some years back, the Boston Police Department put out an RFP for a $1.4 million social media surveillance system. They wanted a bespoke, almost like military style social media tracking technology that they wanted to pay a defense contractor over $1 million to build. This became a subject of a lot of controversy after a Boston Herald reporter discovered the RFP on the city's contracting website, and advocates then made quite a bit of hay about it at the city council. And some of the councilors who are here now were there, thankfully, speaking out against this plan. It was later shelved by the Boston Police Department because of all of the community outrage and outrage on the council. So I think that's a really important example of why we need an ordinance like this. We should have a process that subjects these types of surveillance technologies, the acquisition of these types of surveillance technologies, to council approval and public debate, and not just kind of rely on the ad hoc potential discovery of such an RFP by a journalist, which is what happened in that case. So, if the city has specific language that you'd like to suggest that you think could make that clearer, we would love to take a look at that. Again, I just want to say that it's really disappointing from the advocates' perspective that we've been working on this for many months, years even, with folks on the council, and that it's only really at the last minute that the administration has showed up to raise these concerns about the language. So, I hope that you can understand our frustration on that point. And so as much clarity as you can provide is really going to be useful, I think, for us to move forward.
Hello, Chair. I want to add something to what Kate mentioned, that the section of the ordinance.
Before you do, Emilian, actually, Nayeli from the administration was in line, and I wanted to make sure.
Oh, okay, sorry.
Mm-hmm.
Thank you. I think that Chief Osgood probably can speak more to his department's RFP process and procurement obstacles that he thinks that the ordinance is likely to pose. From my perspective, I don't disagree with what Kate is saying about how there are ways to overcome some of the challenges that we've outlined. I think we're more focused on kind of like operations as they currently exist and the challenges that we think this could pose to projects that are already underway and RFPs that are potentially already underway. I would agree with Councillor Bach that those aren't necessarily unsolvable issues. I think from my perspective, at least, I am not speaking to the BPS, BPD context as much as the other departments that I work with on existing small scale pilots and experiments, and just wanting to work through what those new processes would look like in the context of this ordinance. But I'll let Chief Osgood speak to the RFP and procurement process because he's more familiar with it from a departmental standpoint.
Just really quickly, first on the specific question that Councilor Flaherty that you raised, I don't think it is inherent that this would necessarily have a budget impact on, it might impact sort of the pool of respondents and things like that, but I don't think it would necessarily have a budget impact. I do think that it is useful thinking of Section 4. I think Section 4 sort of considers all the principal ways that we would partner or acquire sort of data or technology, whether that is it's donated, it is through a partnership or research partnership, or whether it's procured. I just think there's some work we need to do to make sure that the way it is specifically outlined in section 4 aligns with both the processes that we have that have been effective for us and upholds the sort of the transparency and accountability that is sort of the intent of this. And I think that section 4 needs some probably to be looked at through kind of like that connection of how we actually work today and what could that look like to make sure that we're advancing the objectives of this ordinance.
Thank you. Councillor Mejia.
Hi. Yes, so I just have to echo really quick that I do believe that it is really sad that we're at the final hour here. There was a hearing that was held. Apparently the administration did not show up for that, and now we're showing up and not ready to dive into the working session. So I just think it's important to note that I too feel a little bit disappointed about the process. And this is probably one of the reasons why so many people don't trust government to work, because everything is like molasses. It doesn't move fast enough for the times that we need to move things. And so I think that, it leaves always a bad taste in people's mouths, because it doesn't really seem that whether you like the spirit of which things are written in, the spirit is great, but the intent versus impact is what I think that our people at this, this point needs. So I'm going to ask a question that I got from on Instagram. So basically, I'll just read it here. It says that they're disappointed at last week's meeting about BPS, that they didn't have the statistics of enrollees. And the question for today is, how many active gang members does BPD regularly come in contact with? And how many active gangs with conflict are there right now in the city of Boston? So that's one question. And then I'm just a little bit confused about the language that we're using in this ordinance. I think that the language is confusing because it says that it doesn't qualify as surveillance data, but yet we're still calling surveillance data. So which is it? I also think that most people don't fully understand what's going on when they give the city their information. Like if I go to the parking clerk and I give my social security number, I don't think it's giving my social security is saying that we're giving it to the entire city. So what does that look like in terms of information sharing? And I gave the example of the social security, it could be any data. But when, and this is in regards to the Boston Public Schools, when BPS schedules a meeting with the student and family after a report has been drawn, it says that a list of attorneys will be provided and that has been vetted by Moya. Are these attorneys pro bono? Who is footing the bill? Who's paying for these lawyers? A lot of families may not be able to afford attorney fees for meetings like this. So I'm just curious about how are we supporting families? And then I'm also curious in terms of the language and interpretation as to whether or not people know what information is being offered to them. And then just as a general note, we've seen these kind of reforms take place all across the country, including Seattle, as Kate pointed out. And we also heard testimonies from the administration that many of these changes are being made here and already are being undertaken. And I think we're more aligned on the issues than we think. And I think that these moments require us to lean in and move the work forward. And the question is, where's the political will to make that happen? That's a lot. I don't know who wants to go first.
Thank you so much. Maybe we can have for the scriveners of the ordinance, either the co-sponsors or the advocates, specifically answer the questions around the attorneys, around specific languages that Councilor Mejia had outright just questions about. And then I think the administration has heard from all of us our frustration about this kind of late conversation. So I don't know who of the.
I can start answering. Can I share my screen to show something about the ordinance? Thank you.
Can I share 2 quick points, Emiliano?
Yeah, sure. Go ahead.
I just think it's going to provide some framing. This is earlier to City Councilor Liz Braden's comment about discussing surveillance at a broader scale and not just focusing on the schools. And I think that's a very good point. And one of the things that I thought would be important to bring up is, there are some ongoing reports and news that are coming about regarding, for example, in Florida recently, there have been reports of the sheriff's office keeping tabs and keeping lists of, essentially these lists are serving to predict the likability that or possibility that a young person will become a criminal. And so they have all these identifiers. I mean, not too different, right, from how we have the 10-point gang data, gang-based points system. So they essentially keep this list of young people who they think in the future will become criminals. And so it's already like predicting, right, from a young age. And so for us, I think the spirit of the ordinance is very much preventative. It's very much, recognizing that we already have such a difficult and burdensome criminal justice system that already is so discriminatory and so broken in many ways. Our hope was to create a ordinance that already starts to deal with some of the root causes, which usually starts with the criminalization of young people who then become older civilians in our everyday society, right? Now, that's not to say that we shouldn't have, obviously, a broader conversation about surveillance at large. And I think a lot of the other advocates will have a lot to say about that. But I just wanted to offer that framing about how this is in many ways preventative. And then also to City Councilor Mejia's point earlier, regarding the pro bono, whether lawyers will be pro bono or not. I do want to say that we've had these conversations for over years with BPS. And, one of the ongoing issues has always been that we as advocates, our organizations, even pro bono and lawyers who are willingly trying to go to schools and talk to students and help their families are consistently blocked and are not allowed in, are not engaged with. And we've actually proposed that we would provide lists of, interpreters, of lawyers, especially from some of our partner organizations. But, it's been difficult and we have sometimes faced resistance to that. So I just wanted to put that out there as well.
Thank you. Oh, thank you. Madam Chair, are you seeing my page, the sharing?
Yes.
Great. Thank you, Madam Chair. So I'm just going to build up on what Kate and Valeria were saying, especially some of the concerns raised by Councilors Isabi George. So first we have to, I think that it makes sense to read the definition of the ordinance because there are some exceptions that I want to go through. So first of all, surveillance is defined as the act of observing or analyzing the movements, behaviors, or actions of identified individuals. So surveillance data and surveillance technology mounts on this definition, so that surveillance data means any electronic data collected, captured, recorded, retained, processed, intercepted, or analyzed by surveillance technology acquired by the city or operated at the direction of the city. And then the definition of surveillance technology says that it means any device, hardware, or software that is capable of collecting, capturing, recording, retaining, processing, intercepting, analyzing, monitoring, or sharing audio, visual, digital, location, thermal, biometric, associational, or similar information specifically associated with or capable of being associated with any identified individual or group. So in section what used to be section 2, now it's section 1663.3, there is a specific provision that would, for example, exempt most of the data collected by the libraries, because it says that the following do not constitute surveillance data and the requirements of this ordinance do not apply to them. So A is surveillance data acquired where the individual knowingly and voluntarily consented to provide information, such as submitting personal information for the receipt of city services. So in this case, if someone goes to the library and wants to get a library card, that would be a city service. So this doesn't mean that the data is not protected, right? The data is protected because the city has to certain obligations in accordance with the terms of services and the privacy policies that the library has with the people. And then finally, surveillance data acquired where the individual was presented with a clear and conspicuous opportunity to opt out of providing the information. So then the ordinance goes on, and there are a lot of actually surveillance technologies that are excluded from the ordinance. So I really don't kind of like understand some of the concerns of the administration when some of the things that they are saying that will be trumped by this ordinance are or either exempted because of how the surveillance data was collected, or because they are exempted just because they are named in the ordinance. And finally, I would also want to mention the following, which is, sorry, it's the section 4, which is about the RFP. Well, actually, the city may seek here, as you can see, may seek but not accept funds for surveillance technology without approval from the city council. So this came up when we were working in Somerville, because the police department there raised the question that they sometimes need to present or seek funds with anticipation in a manner that cannot be coordinated with the city council. So that's why we introduced this. And as Kate was mentioning, this means that it's not that they can or the whole RFP process will be trumped by this ordinance. It's just but the acquisition, using, or entering into the agreement to acquire, share, or otherwise use. Anything that it's outside this, the administration can do it without the approval of the city council. It's just the use and the engaging with the surveillance technology that is being targeted by this ordinance. Thank you, Madam Chair.
Sorry. Thank you very much. So I think we've gone through the counselors, each having their opportunity to ask any questions or to point this. I've indicated where I'd like this conversation to go in the next couple days, if anything, a genuine, attempt and demonstration from the administration. They want something to get done, would really help us to guide the conversation and figure out how we're going to land this. Because if there is genuine looking forward to the conversation and genuinely wanting to do something, then that makes us all inclined to want to come to the table and get a comprehensive piece of legislation done. But if this is not there, then it makes us inclined to think that we're going to have to do this without the administration. And that's not ideal. It's not the goal. I'm otherwise, unless there's anyone who has any burning concluding remarks from any party, you can raise your blue hand at this time to speak. I'm going to go ahead and close out this working session, follow up with the co-sponsors and the administration.
Madam Chair, I'm sorry. I didn't get, all of my questions were not, I had one more question, and some of my questions were in response to Councilor Breeden and Councilor Sabi George, but there was a very specific question that I asked that did not get addressed. So I just want to flag that, if that's okay, Madam Chair.
Oh, specifically about the lawyers, you're right, I apologize. Did the scriveners or about the list of lawyers would be provided to somebody? Are they free lawyers? How are we going to ensure that they're actually competent?
Yeah, I can answer.
That was not the only, I also was curious about, the question that I had is also about the gang database in terms of how we're tracking and how many people we have. I just am curious if that there's that. And in regards to the lawyers, I know that there was some reference made about the attempt that is made. I don't think that nonprofit organizations should continue to bear the brunt of the financial hardships that exist for people to be able to advocate for themselves. So we just need to figure out like how this is going to look to ensure that those who are already suffering don't have to suffer financially as well. So I just need some clarity on that. Sorry about the.
No problem. Is anyone here from the administration can speak to the gang database? I don't think we have anyone from BPD or anyone in stewardship of that.
Don't, that's right, Counselor, I'm sorry.
Okay, and in terms of the attorneys, Attorney Liz, you were going to say something. Attorney Liz.
Just Liz is fine. No, Councilor Mejia, so we are nonprofit, so we don't charge people whom we represent, but we also, at GBLS, my project has me, and then I have half a paralegal and half another lawyer. So, of course, like the number of cases we can take is limited. And although we do think it's really important to connect folks with legal resources, I also think like the attempt of the policy is to, if someone needs a lawyer, like the harm has already happened. So we also try really, to prevent the harm from happening in the first place. But so the lawyers are free, but we are limited in the number of cases that we can take, and kids are not going to be entitled to like appointed counselor or something like that solely because the BPD 11 is written.
Thank you. Yeah, so I guess so that I'm more clear, what I'm trying to get at is we should not be burdening already overburdened nonprofit organizations, and with it. So they are already feeling the financial crunch, and you're right, Lawyer McIntyre, that we need to prevent the harm from being done to begin with, right? So in the spirit of what we're trying to do here is to get ahead of the conversation. But if there is harm to be done, then, and I don't know if this is legal, and I know Councilor Edward knows her business here, is that the city should have a sense of responsibility and ownership of absorbing some of these costs. And I think that that's what I was hoping for in terms of, and I know we're in a recession and I should not be trying to get the city to spend any more money, but I just do think that we have a responsibility to also think about how do we support organizations and families, especially when we're the ones who are driving these inequities. So that's where I was trying to come from.
Councilor Mejia, that's an excellent question. It actually mirrors what we're doing already. We got CDBG money, we got CARES Act money, and that has helped to fund 2 attorneys at Greater Boston Legal Services when it comes to housing. So it's not unprecedented for us to take or direct funds. So I think the issue for us, not even the issue, but the further research would be what funding stream, either applied by the city or applied by advocates or someone to support or bolster this, could be provided to help provide that legal framework. That would require some research.
Thank you, that is all. I yield the rest of my time.
We have more time than you.
Madam Chair, may I jump in?
Yeah.
Yeah, so thank you so much. I want to thank my colleagues, thank the administration, thank all of the panelists. And I'll jump in on just the last comments on the nonprofits. I think our nonprofits provide an incredible service through our city, and we're much stronger because of our nonprofit partners. As people know, I spent the vast majority of my career in the nonprofit life, working with many of you, many of the advocates. And it's really important, while we want to make sure our nonprofits are strong, particularly those who are in the advocacy community, it's important that they keep their hands off city money. So we don't want city money going to them because we want them to continue to be strong advocates. It's hard to bite the hand that feeds you. And so at MAC, where I worked at Massachusetts Advocates for Children, we didn't take city money and we didn't take state money because we need to be strong advocates and hold the government accountable. And so I'm grateful for the advocates out here who are doing just that. I think Chief DePina, I appreciate your comments earlier. And as you know, through my work in this nonprofit, I've had the opportunity to sit on many work groups, many task force, to work with you and others in the administration to try to move policy forward. And so I appreciate the work that you've done and the work that has already been done on the BPS policy. I would argue it is not enough and that it can be stronger. And now is not the time to say, well, we've done it, pat ourselves on the back and walk away. Now is the time that we double down and make sure we are righting the wrongs of the history of this nation, from mass incarceration to war on drugs. And when we know the history, and we know that Boston is not exempt from that history. So now is the time to make sure we're doing everything possible to right the wrongs of the history in this country when it comes to policing, when it comes to oversight, when it comes to surveillance. We know the history. We know that our young people in our schools are being criminalized. There's a long history of it. There is data. We can look at suspension data. We can look at all of this. And so my hope is that we're not going to rest with what the school committee has already voted on. We know that that policy isn't enough. We know that from the examples that Attorney McIntyre has already shared, that there are several problems and that the students and the clients that she represents would still be caught up in some court or some sort of drama based on the new proposal that was already passed by the school committee. So it does not go far enough. My hope is that we will in fact make sure that if we say that we believe in the spirit and the intent and the values, that we are going to move forward. There are 9 days left before the legislative cycle of the Boston City Council ends. And 2 of those days are Saturday and Sunday. Okay, so there are 7 work days left. If we're going to get this done, I would really appreciate a marked up version from the administration saying what their concerns are, what their questions are, what their suggested language would be. We have that from the advocates. We have that from the advocates. We have language that we have been working on and we're ready to move forward. As our chairwoman has already said, it is not my goal ever to jam something in. I want to make sure that we are moving forward legislation that is thoughtful and that everyone has had the chance to weigh in and get their thoughts down on actual paper. So that is what I am asking the administration to do, to put it on paper so that we can move forward. The city council is prepared to move forward with a vote. And I'm gonna follow the lead of our chair and the advocates and my colleagues who have sponsored this with me to see when that timing is. But I'm very mindful that we don't have much left in this legislative cycle and that the sense of urgency is here. This is not, we've already done it, so let's just see what happens, or let's just push and kick the can down the road. The urgency is here. So that is my hope that we will move forward and we will get this done. Thank you so much, Madam Chair.
Thank you very much. Any other concluding remarks?
If I could step in, Madam Chair.
Yes.
Thank you, Madam Chair. I just want to touch on the gang database piece really briefly. One of the issues with what BPS already passed is that they allow the inclusion of alleged confirmed gang affiliation reports. The problem with this is that unless it's news to me right now, BPS doesn't keep a gang database. And so in order for them to confirm that somebody is in a gang database, it would actually require communication with BPD about an individual who may or may not be on this confirmed gang database, but at that moment, you're actually already sharing student information. On top of that, the reality is, and we have a hearing on this that I don't think is going to be held this year, but the gang database is racist. I mean, it's discriminatory. It does FIOs based on clothing, on association. You can end up on the gang database without ever having been seen committing any criminal act. That you can be an alleged gang member and confirmed. And frankly, I have an issue with BPD having that process legitimized by BPS. And so the reality is our solution actually makes it so that you can't contain information pertaining to suspected, alleged, or confirmed gang involvement, affiliation, in association, or membership in this ordinance. So as far as the gang database issue goes, which I think Councilor Mejia raised, right now the issue as I see it is that the BPS policy allows for it to be a part of their reporting and allows for them to have communication with BPD about individuals when they're making a decision as to what to include in a report, unless BPS is keeping their own gang database, which would be news to me and would be incredibly problematic. It requires them to actually have conversations with and confirm with BPD as to whether or not somebody is on that file, which is in itself a communication which is in itself problematic. And so I think that one of the things that this ordinance seeks to fix is that it doesn't allow you to do that anymore. And the current BPS policy does. And so I look forward to seeing a markup from the administration. I think I stand by this language. I stand by the protections here. And I look forward to seeing where the administration's problems with this language is and where they think this doesn't go further enough. Because frankly, for me, it's incredibly troubling that what I've heard hasn't been, here's how we protect more people. Here's how we make this more protective. Everything I've heard is, let's not protect them that much. Let's lessen the language here. That might create more paperwork for us. We might have to disclose more things. And that for me doesn't cut it, right? Like that's incredibly problematic. I haven't heard a single solution. Not one person from the administration has said a single thing that said, this is how we can actually protect more people. Even in defense of the BPS policy, it's not that this protects more people. It's that this is what we've already done and we would like to not go further. And that's a problem for me. I'm just going to put that right there, especially considering that you've all missed hearings and those things add up. And then you end up here making these kinds of arguments. And frankly, I'm gotten to a point now, I've only been here for less than a year. I will call the administration out repeatedly when they continue to miss hearings and show up to ordinances and then make that a hearing. It holds us up. We got 7 days to do the work. I look forward to getting this passed. It's got my vote, with or without a single edit from the city. And so that's where we're at.
Madam Chair, if I could briefly respond, just real quick. Our policy is very clear that we do not allow any reference to suspected or alleged gang involvement, affiliation, association, or membership. So we already made that prohibition and that does not happen. It's clearly stated in our policy. And as I mentioned right at the beginning of this conversation, we acknowledge that we did not reach a full consensus with all the parties that we work with above and beyond the group that's here around our policy. That's why we agreed to create a working group to continue to monitor and provide updates. So by no stretch of the imagination are we saying we're done here, but we just want to make sure we continue the conversation and work appropriately. So I just want to clarify that, Councilor Royal's comments are very inaccurate. Our policy does not allow for the sharing of suspected or alleged gang involvement.
Chief Tapina.
So this is exactly what
my comments inaccurate.
I'm
So
so
I'd like to.
No. This is what I exactly wanted to avoid. Chief Tapina, I don't appreciate the characterization of anyone's comments today being inaccurate. Again, as stated before, this conversation could have happened before. And there could have been a back and forth. So we're not going to have this back and forth over accuracies or not of the co-sponsors of this particular ordinance. Is what is the subject today and how this or doesn't work or adds to.
Apologize, Madam Chair.
Mr. Tapina, I'm trying to land this plane as an in this working session so we can get to additional things that this councilor is trying to pass in as the limited time that Councilor Janey has mentioned. So at this point, and I apologize, Councilor Roy, to cut you off, but I do want, if there's anybody else, and Councilor Roy, you can have the last word, but I mean, I really want that to be the last word.
It'll be very short. 1 second
before you go. Anybody else? Going once? Going twice?
Councilor Wu, the third co-sponsor would like a chance to make a final statement. I'm sorry, I'm not sure if you can see her.
I see her.
Okay.
I see Councilor Mejia raise her hand. I know Councilor Arroyo would like to speak.
Yeah, I'm not speaking. I have a
question. Before anyone speaks, I am trying to get a final list.
I'm just curious about what we're asking. Like, is this the end of the working session?
This is the end of the working session, and I'm trying to get final remarks.
Okay.
So,
Councilor, I don't need anything. I'm good.
Thank you. Anybody else has a final remark before Councilor Arroyo finishes this, and then I will promptly end this after he speaks.
Madam Chair, I'm sorry, my camera's not working. So if I may, I'll keep it very, very short. Just to say, so much of what I've heard today really reflects the fact that, or the assertion that this work is already being done. And I just wanted to appreciate that and thank everyone for their work, and then continue to push on the need for transparency, right? So even if that work is happening, we need to be sure that it is happening. We need to be taking that work out to the public and then seeking their feedback on that. And so, I think some of the back and forth has been around what what is real, what is not. We can't be sure of any of that until we are surfacing it. And so that is the goal of this ordinance, is to just legislatively require and codify what we hear as the intent of the work that is already happening, and then to clarify some of these areas where even in the back and forth, it feels like generally people are wanting to end up in the same intentionality, but we need to be sure of that, which is the job of the city council in our oversight role and our legislative role. So I just want to thank everyone. I think we're aiming towards the same place, but emphasize that this is not about us in this room. It is about the public knowing and being sure with us in this room.
Thank you, Councilor Arroyo. You have the final word, and I prefer.
I'll make it very brief.
Thank you.
To be clear, what the BPS policy allows is for the inclusion of what they call confirmed gang affiliation. Confirmed gang affiliation would still require communication with BPD to figure out if somebody's on a gang database, unless, again, BPS has a gang database. We can parse language as to whether they're suspected or affiliated. Here's the deal. You can end up as a confirmed gang member by doing zero criminal activity simply by what you are wearing and who you are associating with. It does not make you a confirmed gang member. It still makes you an alleged gang member. And so whether or not you have an issue with the language that I am saying about a confirmed or a suspicious or an allegation, at the end of the day, the language that the BPS policy allows for is confirmed gang member. I don't know how they would get that information without communicating first with BPD about a student, about that student's name, about that student's access. And then, just so we're clear on what confirmation means, confirmation could mean that they have been seen in the company or the vicinity of people who are also allegedly gang members, that they have been wearing clothing like a Cleveland Indians hat or whatever it may be, that gives them points on a system that then makes them a confirmed gang member. And so at the end of the day, you know, that the parsing of language here doesn't really matter to me. At the end of the day, what BPS's policy allows for is the inclusion of somebody's confirmed gang affiliation, which is based on very soft observations, that is based on very problematic racist observations. And so when we talk about the criminalization of our children, it's precisely that I mean. And so when we talk about whether or not I'm being inaccurate or accurate, everything I just said is accurate. And whether or not BPS is willing to say today that they do not have to speak to BPD about a student in advance to figure out if that person is actually, quote unquote, a confirmed gang affiliate, whether or not they're keeping their own files on that, I would find incredibly interesting.
Thank you. Thank you very much. The goal was a working session. I think we had a robust hearing in the end. And so we have several different points and perspectives. We will get to work. I look forward to hearing from the administration. Thank you to the co-sponsors. Thank you to the advocates. Have a good day.
Thank you, Madam Chairman. Madam Chair.
Thank you, Madam Chair.